Straight ahead on Law&Crime Daily, a man accused of killing his parents stands trial as jurors are selected in the Wisconsin murder case of Chandler Halderson. And after more than 5 million petition signatures and uproar about a truck driver's 110-year sentence, the Colorado governor steps in to help Rogel Aguilera-Mederos. Plus, a jury weighs the fate of a former CEO in California as deliberations resume in the fraud case for Elizabeth Holmes. Then later, jury selection for Dayonte Resiles gets pushed back a day as the 27-year-old is retried in a 2014 murder. Law&Crime Daily covering court cases from coast to coast. Welcome everyone to Law&Crime Daily. I'm Brian Buckmeyer along with Terry Austin. Wisconsin murder case of Chandler Halderson gets underway as jury selection begins. Halderson is accused of killing and dismembering his parents in July of last year. The 23-year-old faces multiple charges, including first-degree intentional homicide, mutilating a corpse, hiding a corpse, and lying to police. In July of last year, Halderson told investigators and local TV stations that his parents went missing after leaving for a July 4th weekend trip. Days later, he was arrested after his father's torso was found on property belonging to his girlfriend's family. Then, his mother's legs were found in a nearby county. On Monday, jury selection for the trial began in Madison, Wisconsin. That's where Law&Crime Daily reporter Sierra Gillespie joins us now live with the latest developments with potential jurors.
Brian, temperatures outside are freezing here in the capital city, but inside the Dane County Courthouse, jury selection is heating up in the state of Wisconsin versus Chandler Halderson. Now, the biggest hurdle that defense attorneys and prosecutors are running into is the familiarity with the case, and that many potential jurors have seen TV station reports or read articles about this highly publicized case here. So far today, a couple of potential jurors have already been dismissed, saying they are too close to the case, some even saying they believe that Halderson is guilty and that their opinions could not be swayed with any amount of evidence. Now, all this as the defendant, Chandler Halderson himself, listens on as many potential jurors point the finger and say he is guilty. But Halderson's response has been pretty stoic. He pretty much just blinks in response. Occasionally, he writes on a legal pad in front of him or takes a sip of water, but there isn't much response or even much conversation with his defense attorneys. Now, on the opposite side of things, we have heard from some other potential jurors who say that while they're familiar with the case, they believe that the media coverage here in Madison, Wisconsin has been swayed and slanted against Halderson, saying he's guilty before we've even gotten to opening statements. Now, so far today, about a dozen potential jurors have been dismissed for a variety of reasons. In the end, there will be 12 that are chosen with 6 alternates, and so far, majority of the demographic we've seen is about a lot of white people who are mostly aged 30 and up. So jury selection is still underway here, and opening statements are expected to begin tomorrow. Brian?
Thank you, Sierra. Joining us today is criminal defense attorney Bernardo Villalona and Terry Austin. Bernardo, it's an understatement to say this case is an uphill battle for the defense. So what kind of juror are they looking for to get anything but a guilty verdict?
So, Brian, when you have a case like this where there's so much evidence, you have the body that's recovered as well as the statements that were provided by the defendant, it really doesn't matter because you have so much strong evidence. You have the DNA, you have physical evidence, and you have the statement. So any juror would be able to convict based on the evidence presented. The only thing you really need to ask of these jurors, are you willing? Can you follow the judge's instruction? If I prove my case beyond a reasonable doubt, it's will you find him guilty? That's it.
So Terry, Bernardo outlined many of the strong evidence in this case, but what's the smoking gun in this case? What's the strongest fact that gets the prosecution to the verdict they're looking for?
Where do we even begin, Brian? There are so many smoking guns. This may not seem to some like it's a smoking gun, but to me, the fact that he misled the authorities. Right then and there, I think you have to look at the fact that he is not credible, that he's hiding something. Obviously, those Google searches were very serious because he was looking for bodies found. That, to me, is indicating that he has some consciousness of guilt. Then the authorities went to the home and sections of the floor and the wall were missing. That's quite odd. What does that mean? Was there blood on the floor? Was he trying to cover something up? And then, obviously, the fact that they found the remains of both his parents at different places, and his phone was connected to where the remains were found. So there are so many smoking guns here. I don't think he's going to get out of it. As Bernardo says, they just have to look at the facts and find him guilty. The question is, how long will it take them to get to that verdict?
Now, Sierra, what can we expect moving forward as opening statements looms in the coming days?
Yeah, so Brian, first we have to find that jury and then the highly anticipated opening statements. The biggest question mark we have right now is, will Halderson take the stand in his own defense? And actually just moments ago, some potential jurors were dismissed because they said that if Halderson did not take the stand, they would automatically find him guilty, and there was nothing that could sway that. So here the biggest question mark is, will Halderson take the stand? And we're all eagerly waiting to see what will happen there.
Thank you very much for your reporting, Sierra. We'll make sure to get more updates as this case continues. Jury selection was set to begin Monday in another Wisconsin case, the murder trial for Theodore Edgecombe. The trial has now been moved to January 18th. We're told the judge has COVID-19. Edgecombe is accused of killing immigration attorney Jason Clearman last year in Milwaukee in what police are calling a road rage incident. Edgecombe's defense attorneys claim he acted in self-defense. They argue Clearman's car, which his wife was driving at the time, tried to run Edgecombe off the road while he was on his bike. The criminal complaint says the two got into a fight and Edgecombe allegedly plunged Clearman through his open passenger side window. In the video, you can then see the car follow Edgecombe onto a bridge. That's when Clearman got out of the car and Edgecombe shot him. Edgecombe claims Clearman had a knife. The prosecution says he fled the state. He was arrested 6 months later in Kentucky. Edgecombe, a black man, is receiving support from racial justice activists, as there are comparisons to Kyle Rittenhouse, who was white and was acquitted while claiming self-defense in nearby Kenosha. The 31-year-old faces first-degree reckless homicide charges and felony bail-jumping charges. Newly unsealed documents reveal convicted sex offender Jeffrey Epstein paid one of his accusers $500,000 to settle a lawsuit in 2009. This comes ahead of a scheduled hearing Tuesday in the lawsuit Virginia Giuffre filed against Prince Andrew last year. Giuffre claims she was forced to have sex with the Duke of York when she was younger than 18. But Prince Andrew's lawyers are expected to argue the 2009 agreement between Giuffre and Epstein shields him from lawsuits since it covers, quote, other potential defendants. Prince Andrew has said he doesn't remember meeting Giuffre despite a photo showing them together. He stepped back from royal duties after an interview with the BBC about his relationship with Epstein. And more developments in the Jeffrey Epstein circle as federal prosecutors request a judge dismiss claims against two Manhattan jail guards who say they falsified records about the night the financier killed himself. In August 2019, Tova Noel and Michael Thomas were the guards on duty while Epstein was awaiting trial for sex trafficking. The pair allegedly fell asleep and browsed online instead of checking on Epstein's like they were supposed to throughout the night. The next morning, he was found hanging in his cell. The medical examiner ruled it a suicide. Both Noel and Thomas say they lied to make it seem like they were monitoring Epstein. Federal prosecutors say the two cooperated with deferred prosecution agreements made earlier this last year. Last week, Ghislaine Maxwell, Epstein's former girlfriend, was convicted of sex trafficking, among other charges, for recruiting and grooming young girls for Epstein to sexually abuse. Still ahead on Law and Crime Daily, after millions of signatures and increased outcries, Rogel Aguilera-Mederos' 110-year sentence is commuted with the help of the governor. But first, could a federal fraud trial that's been going on for weeks be coming to an end? We check in on the Elizabeth Holmes case in California as the jury deliberates.
Hi, this is Dan Abrams with exciting news for all of our Law and Crime followers on YouTube. You can now get the live Law and Crime Network with YouTube TV for all of your daily live trial coverage, legal news, expert analysis, and original true crime programs. Subscribe to YouTube TV today and then locate Law and Crime in the channel guide. And for only $1.99 a month, you can add the network to your bundle. Watch Law and Crime every day with YouTube TV. We put you in the jury box.
Welcome back to Law and Crime Daily as we head now to California, where a jury says they have reached a consensus on some of the charges in the federal fraud trial for businesswoman Elizabeth Holmes. Monday afternoon, the jury came forward with a note saying they couldn't come to a unanimous decision on 3 of the 11 counts of fraud and conspiracy Holmes is charged with. After reading part of the initial instructions, the judge sent the jury back into the deliberation room. Those charges stem from the downfall of her blood testing startup company, Theranos. The business was once touted that it would revolutionize blood testing, but prosecutors say Holmes lied to investors and patients about the company's technology to generate hype and raise hundreds of millions of dollars in funding. Her defense argued other leaders in the company were to blame. If convicted, Holmes faces 20 years behind bars, a fine of $250,000 plus restitution for each fraud charge. After months of testimony from more than 32 witnesses, Holmes took the stand in her own defense. She testified about emotional and sexual abuse from her ex-boyfriend and former CEO of Theranos, Ramesh Sunny Balwani. Balwani faces the same charges as Holmes and is set to be tried in February. Like the Holmes jury, criminal defense attorney Bernardo Villalona and Terry Austin are back to discuss the case from 2021. Terry, the Holmes jury has been able to choose when they deliberate. With the New Year holiday creating a large break, any potential appellate issues you see?
You know, there are 3 categories for appellate issues. First of all, maybe there was legal error or judicial misconduct or ineffective assistance to counsel. Here, the fact that this jury was able to take these long breaks, they could have been exposed to family and friends. There could have been some conversations. They could have let outside influences affect their decision. So, you know, that could very well be one ground for appeal. But if Judge Davila basically questioned them when they came in, made sure there were no issues, I think that will be all right, and there won't be a ground for appeal here.
All right, we'll see how that plays out. Bernardo, the jury note sent saying they can't reach a consensus of 3 of the 11 charges. What do you think that means, and what are the possible outcomes?
Well, what we do know, since they haven't been able to reach a decision as to 3 of the counts, is that they have a verdict as to 8 of the counts. So we don't know whether it's guilty or not guilty, but we do know that 2 of the counts refer to conspiracy to commit wire fraud, and then 9 of the counts have to deal with wire fraud itself, but dealing with different amounts of money that was actually defrauded by these victims. So in terms of what's going to happen, I'm surprised that the prosecutor nor the defense requested to actually take that verdict and have them stop deliberating. We'll see how much longer that the judge is going to allow them to deliberate on this matter. But my projection is that they'll take the split verdict.
All right, we'll see what happens and when that split verdict will come up. Today, another day, we'll see. Hopefully not sometime in 2023, though. Switching now to Texas, where a total of $20,000 in reward money is now being offered to catch a 14-year-old accused of shooting and killing 3 teenagers at a Texaco gas station a day after Christmas. A 4th teenager was also injured in the attack. 33-year-old Richard Acosta and his 14-year-old son, Abel Elias Acosta, are charged with capital murder. Police say the 14-year-old fired more than 20 shots into the store and got away in a white Dodge Ram truck by his father. According to police, Richard turned himself in, but the younger Acosta has been on the loose since the shooting. Officials say the shooting may have been retaliation against one or more of the victims. Coming up on Law and Crime Daily, a more than 100-year sentence reduced for Rogel Aguilera-Mederos, the truck driver convicted of killing 4 people in a Colorado car crash. Plus, the retrial of an accused killer is delayed another day, as Dayonte Resiles' murder trial will soon be heard by a new jury in a Florida courtroom. Welcome back. A big development in the case of a truck driver sentenced to more than 100 years in prison for a crash that killed 4 people. His sentence has been reduced. Law and Crime's Anjanette Levy is here with how it happened.
Brian, Rogel Aguilera-Mederos' sentence of 110 years in prison sparked outrage in Colorado and across the country, but now the governor of that state has commuted his sentence to 10 years. A judge sentenced Aguilera-Mederos to 110 years in prison last month for the 2019 crash. The judge said at the time that state law required him to sentence Aguilera-Mederos to consecutive sentences. A petition to reduce the sentence garnered more than 5 million signatures online. Then, in an unprecedented move, prosecutors asked the court to reduce Aguilera-Mederos' sentence to between 20 and 30 years. The judge in the case was actually going to reconsider the sentence at a hearing next week. But late last week, Governor Jared Polis granted clemency, commuting the sentence to 10 years. Now, Aguilera-Mederos' lawyer, Jim Colgan, tells me that his client is pleased by this result and is also humbled by all of the support that he has received from the public. But the family of Bill Bailey, one of the victims killed in that crash, called Governor Polis a despicable human being in an interview with a TV station in Denver because the governor made that decision ahead of the hearing next week. Brian?
Thanks, Anjanette. Let's bring in criminal defense attorney Bernardo Villalona and co-host Terry Austin to discuss the tragedy on I-70. Terry, as you hear from the victims' families, do you think the governor made the right decision?
I do, Brian. I mean, this is a very difficult case. We know that these victims have been heavily impacted, and he was going 85 miles per hour. And the question really is, could he have avoided this accident? But he said that the brakes failed. There doesn't seem to be any contention as far as that's concerned. And if it really is a true accident, then I think the amount of time, 110 years, is way too long. And I think it was the right decision, even though the timing might not be right, to bring it back down to something that is far more reasonable for a case like this.
Now, Bernardo, that's kind of focusing on the what. Your thoughts on the how we got here. Do you think the governor should have stepped in before the judicial process was done?
I think it would have been difficult for the governors to step in because it's unprecedented. When you're dealing with cases like this, it's the prosecutor's office that takes lead. So for the governor to have stepped in before there was a sentencing date, it would have been improper. However, in this case, I do see that it was proper for the governor to step in because we're dealing with a state that had a mandatory sentencing. That's how we got to 110 years. And it's only the position of the governor who would have been able to make any changes unless the prosecutor would have dismissed some of the counts, which would have lessened the mandatory minimums against him.
Now, Anjanette, with a 10-year sentence, what's the soonest Aguilera-Mederos could be released?
Well, Governor Polis, Brian, wrote in his letter to Aguilera-Mederos that he could actually be considered for release, come up for parole on December 30th of 2026. That would be exactly 5 years from the date that his sentence was commuted. And Jim Colgan, the attorney for Aguilera-Mederos, told me that there's really no reason for him not to get that parole because he doesn't have a criminal record and he believes that he will be a good prisoner inside the prison system.
All right, thank you for that update, Anjanette. When we come back, a defendant who's been in jail on murder charges for years will have to wait another day. Jury selection is delayed in the Dayonte Resiles retrial. Welcome back. Jury selection is moved to Tuesday in the Florida courtroom for a man who's being retried for murder. This after delays with some of the state's evidence. Dayonte Resiles is charged with first-degree murder for allegedly killing Jill Halliburton Sue and leaving her body in her bathtub in her home in 2014. Prosecutors allege Resiles broke into Sue's house to burglarize it, but discovered she was home. Resiles allegedly tied her up and stabbed her more than 20 times. The now 27-year-old was on trial for murder in late November and into early December, where the jury deliberated for 5 days before coming back with a manslaughter verdict. But the judge declared a mistrial after one juror disagreed with the verdict. Resiles also made headlines in 2016 after he escaped from the Broward County Courthouse while waiting a hearing. He managed to break free of his shackles and striped jumpsuit before getting away with the help of several accomplices. On Monday, as jury selection was about to start, Resiles' defense team filed several motions which were denied by the judge, including moving to dismiss 2 charges on double jeopardy grounds. The state said since a verdict wasn't previously reached, double jeopardy doesn't apply. Their request for removing the death penalty as a possible sentence was also denied. Bernardo, do you agree with the state that double jeopardy doesn't apply to the two charges the defense tried to get dismissed? And if so, why?
So in terms of whether double jeopardy applies, I agree that double jeopardy doesn't apply because you don't have a verdict by a jury stating that whether he was guilty or not guilty. You ended up having what I would call a mistrial because you don't have a consensus as to the verdict. So the state would be entitled to retry Mr. Resiles again.
Now, Terry, delays because of evidence, that kind of makes me raise my eyebrow or so. Does that mean that we should expect new information in this retrial that we didn't see in the first?
Not necessarily, Brian. I think that they're just talking about maybe scheduling of witnesses. I mean, the mistrial was just declared on December 8th. That was not that long ago. And I don't think that there's additional evidence. We know that there was DNA found on that belt, and we know that there was DNA found on the knife at the scene. It could be that the defense is looking to see whether or not that cross-contamination DNA has more relevant information that they can disclose to the jury this time around. But I definitely don't think that there is a whole slew of evidence that they're going to bring for this new trial. They just haven't had enough time.
Now, Bernardo, in let's say like 20 seconds or less, I always ask people, retrials, who has the advantage, the prosecution or the defense?
So it says that the prosecution always has the advantage because now they know what the defense is going to go with. So now they can strain their case to be more specific to try to contend any type of allegations that the defense is going to go with.
Yeah, I know many people, especially defense attorneys, I'll put my hand up for this one, say the element of surprise is oftentimes the defense's strongest weapon in a case. With that being gone in a retrial, it's going to be interesting to see how this plays out. Of course, you think, why didn't he take a plea in between this retrial, mistrial, whatever it may be? Well, Bernardo, Terry, thank you very much for your input. And thank you for joining us here on Law and Crime Daily. We'll see you next time as we discuss justice in America.